All right, so we're going to talk about using pooling to extend the lease. So in other words, to pool land together, so though you don't literally have a oil well on the land that you've leased, if you can attribute some oil and gas to that, give them a share from what you're producing on another property, because that land is pooled together, you may be able to keep that lease. And as we'll see, that can create all kinds of potential problems, litigation, etc. So, as a reminder, pooling is when you bring land together, usually for one well. So you're bringing together either different small tracts or fractional interests. 4 different people own a quarter of the mineral interest, and you're pooling that together to drill a single well. Often you're getting enough together for a single drilling unit. Unitization, by contrast, that's different. That's when you're taking all the wells on a given reservoir and operating them together to extract as much oil and gas as you can from that whole reservoir. Much more difficult. Often in the United States, it's only done for secondary production after primary production is tailing off. All right, so here's a typical pooling clause that you would see in a lease. The lessee is hereby given the right and power to voluntarily pool or combine the acreage covered by this lease with other land, lease, or leases. Operations for drilling on or production of oil or gas from any part of the pooled unit shall be considered as operations for drilling on or production of oil or gas from the land covered by this lease. For the purpose of computing the royalties, there shall be allocated to the land covered by this lease and included in said unit a pro rata portion of the oil and gas produced from the pooled unit. Such allocation shall be on an acreage basis. All right, so the archetypal situation you're thinking about is, let's say you need 40 acres for a well, and these are each 20 acres, and so you're only going to put one well on this land. So each of these landowners have 20 acres. What will happen is the oil and gas company will just put a well on one piece of land, right? 40 acres for each well. It'll just put a well on one piece of land, but it will pool them together. And you can imagine this party saying, well, technically, isn't your lease over? To keep that lease, you had to drill for oil on my land and continue producing it. And that hasn't happened, literally. So the pooling clause just says, no. You're getting half of the oil royalty share. So let's imagine that the royalty share for both landowners is 1/8. So you're getting 1/16, half of that 1/8 of all the oil and gas that comes out of this well. So you're getting oil that is attributed to your property. You're sharing in it on an acreage basis. You have half the acreage. You have 20 of 40 acres. And so you're getting half of what you would get if all the oil was being produced from your property. And so the pooling clause just says, as long as this well keeps producing oil and giving it to the neighbor that it's pooled with, then you get to keep that lease. So that kind of makes sense. But we'll see that there's lots of room for shenanigans with the pooling clause. So, the kind of legal questions that can arise, one is the pooling has to be in compliance strictly with the lease terms. Partially that results, we know that often these leases are drafted by the oil and gas companies, by the lessees, and so they're often construed against their interest. Also, I think you'll see a strain as we go throughout the rest of the course that pooling, maybe seems a little strange sometimes to the courts, and at various times they seem a little bit skeptical of it. So you're only going to be allowed to pool when you're doing so strictly in compliance with the lease terms. So if the lease says you can only pool in certain circumstances, or you can't pool in other ones, then you're going to have to comply with that strictly as the oil and gas company trying to pool that land. Also, apart from anything it says in the lease, your pooling has to be in good faith. And we'll see that what is in good faith can sometimes be hard to determine. Now, There's some other questions. Can the lessee pool more than once? The lease gives the right to pool, but what if, there's pooled into one drilling unit with one neighbor and that's dissolved, maybe there's no production or the production runs out, and then can you pool again with the other neighbor? There's also issues about the acreage size. So sometimes a lease will say you're only allowed to pool if there is only to meet a minimum acreage requirement that is prescribed by the Railroad Commission or other oil and gas conservation commission. So if I've already got 40 acres, don't pool me with somebody else if the field rules call for 40 acres, right? But sometimes that can create complications because occasionally the lease will say, oh, well, if it as long as the oil and gas conservation permits. And maybe the Oil and Gas Conservation Commission says, oh, you only need 40 acres to drill, but you can have a bigger unit. And so that can create issues with the pooling clause. Okay, another pooling issue that sometimes arises. Can the lessee pool after a wet well comes in? Remember that Carson case under the Mineral Interest Pooling Act where there was already a well drilled and then after the fact, the lessee oil and gas company tried to pool with surrounding neighbors to cut them in. And the person who had the lessor with a well on their property said, wait, you've already drilled, so there's obviously no need to pool to bring in these parties, and so I don't want to share with them. So there can sometimes, if the lease says you can only pool to secure development, it's going to be harder for you if you've already drilled the well. Another question, can you pool and set the date of pooling at a prior date? So again, what if a well already came in and you say, oh, really, shoot, all these neighboring landowners should have gotten a share of that. Are you allowed to do that? And at a minimum, you can say that's difficult to do. All right. Now, just to give you a sense of some of the shenanigans that companies can get to, let's imagine a friendly company, Acme Oil Company, and let's say that they've been busy working on other prospects, and they have 6 leases right here, and each of those leases is on 20 acres. And let's say that you need 40 acres to drill, or that's the normal drilling unit. And those 6 leases are reaching the end of their primary term. Acme is got its rigs busy elsewhere. It would like to drill as little as possible right now because it's working elsewhere, but it really wants to keep these leases even though they're reaching the end of their primary term. Well, how could Acme use pooling to accomplish that? Now look at this, look at these different units and why don't you just think on your screen or point with your fingers, like where would you pool this to allow production? So how many wells do you have to drill at minimum to keep all these leases? Well, one option would be you could just drill 3 wells and then drill these pool these neighboring properties, and so you've only drilled 3 wells and you've been able to keep all 6 leases because they're all pooled together and production on this one counts for this one, production on this one counts for this one, production on this one counts for this one because they're pooled together, and under the pooling clause, most pooling clauses, it's going to count. Okay, so that's one option. Is there a way that you could drill even less and keep all these leases? Well, here's one example. What if your 40 acres, you just take a corner of each property and all of this property and pool it together? Now remember, the sort of basic oil and gas lease says if you have production anywhere on that property of even a small portion of that property, you get to keep that lease as long as oil and gas is produced. So what this shows is that Acme could, with one well, keep all 6 properties, keep 120 acres of leases. And you can see how, that kind of looks like pooling in this context. These are just shenanigans to keep those leases. And is that going to be allowed? Is that in good faith? There can be other more subtle problems with pooling. And we'll see these throughout the course, but let's talk about how these might work. So let's imagine that this time Acme has just 4 leases, okay, with X, W, V, and Y here, okay? Now, it owns 2 properties outright. So Acme owns those. What's better about owning a property outright? Well, you get to keep all of the oil and gas that you produce there. So Acme, let's say, keeps 7/8 of the production it gets on X, W, Y, and V, which is okay. But it keeps 8/8, it keeps all of the production on those 2 other leases. And sometimes, to keep all the production, that's how you go from because you're spending a lot of money on the well. So getting that last 1/8 can be very valuable to Acme. Okay, now let's say Acme has a notion that this is kind of where the reservoirs are located. Maybe it doesn't know for sure, but its best guess is oil, that's where oil is located. Now, Acme is concerned if it did what we did in the previous one and tried to keep all 6 leases with just 1 well, that's not going to work. So it's going to have to pool in these whole leases together to keep production. Now, how would Acme want to pool this land? So think about that. Point to how you think it would like to pool that land. Take a second, think about where you might want it. Now, there's a bunch of ways to do it. You could do it, as we suggested before, just north-south, right, up, down, across, 1, 2, 3. But the problem for Acme there is it doesn't think there's really oil under this tract of it. So what if Acme instead said, you know what, I'm going to pool this way, and I'm going to pool this way. And remember, under the lease, the oil and gas company has a lot of discretion about how to pool. And so it pools its land with the land of Y that contains the reservoir. And similarly, X gets pooled with W. Now, who's going to be upset about that? X and Y, because basically they're going to have a well on their property and they're only going to be able to keep half of the oil. Now, that's true whether it's north-south or east-west, but the problem is that well will produce less oil than if you had a well right here that was producing that whole reservoir, because instead there'll be 2 wells sharing that reservoir. So X and Y are going to be not very happy about this pooling setup. We know the company has a lot of discretion. Is this good faith? Is this pooling in good faith? Note also that Acme would pool the rest with V. Okay, now is that in good faith? I mean, again, that might be exactly what you would think even if you didn't know where the oil was. Just pool them all north-south. Okay, so Acme pools with V. Now, could somebody complain about that? Well, if you did all north-south, right, if you did all north-south connecting these 3 properties, W might say, you know what, you really should have pooled me east-west because I want a share of that production from V. Because if we just go north-south, it's going to be Acme and W splitting nothing. So you can see that the oil and gas company has a lot of discretion in how it pools, but depending on how it pools, there can be very different results for all the parties. And so it can be, sometimes it's a little bit of a gray zone whether that pooling was in good faith. All right, let's talk about a case where we have a fair amount of evidence that the pooling was not in good faith. So this is on page 310 in your books. What happened here is that the lessee, the oil and gas company, formed a 688-acre drilling unit that included portions of 8 leases, covering 2,250 acres, 2 days before the end of the primary term of several leases. So this is kind of the canonical bad faith pooling situation. You have a bunch of leases about to expire, and you try to keep them all with one pooled unit, with one well. Some clearly non-productive property was included in the unit. So they, just get in the corner of certain leases and basically just to hold on to that lease overall. And then some clearly productive property was excluded from the unit. So they didn't use all of everybody's property, they just used corners. And sometimes that meant that there might be a whole property, let's say the whole property was 100 acres and it had oil on all of it, but they only put 20 acres in the unit. So because remember, within a pooled unit, the oil is shared on an acreage basis. If you just have 20 of 100 acres, that means you're just getting 20/100ths, 1/5 of the oil from the well. It was also evidence that the purpose of the unit was to extend the leases and that the lessee, the oil and gas company, wasn't planning to drill additional wells. It just wanted to hold on to these leases in case there might be oil on them. So there's this letter, here you go. It's basically, it says, we don't really need this unit to drill. We already have authorization to drill. We already have actually drilled that unit. Now that's the drilling unit. It's not unitization. This is for pooling. So we've already drilled that unit well, and it's being completed. So we don't need to pool. There's no requirement. But the majority of these leases expire in 5 days. So this is a May 20th letter, and the leases expire May 25th. Okay. Also says, we got to file this unit declaration to hold the majority of the leases. So it's very clear that the intent here is to hold leases. It's not just, okay, this is the way it happened to produce it. Sorry, it didn't work out well for you. This was actually, the whole point was to hold on to these leases. And if you actually look at the pooled unit, you can see it's pretty bizarre. So you see we've got section 3 here, but the unit doesn't follow the section boundaries. Instead, it just takes a corner of a bunch of other areas so that it can hold on to all those other leases, okay? So there's basically, it takes a little corner here, takes a little corner here and here and here and here and here. And so there's an effort to basically keep all those leases with just one well. So you can keep in mind that section 3 lease by itself was enough for a full unit. So there's no need to pool. And as I said, no plans to drill more wells. Some of that productive property in section 3 was excluded. Non-productive property here in section 81 was included. So this is a pretty paradigmatic bad faith example. As we saw from the letter, purpose of the unit was to extend the leases. Now, what about lease limitations on pooling? So, companies can use pooling for all these shenanigans. There's the good faith limit, but it's never great if the only way you're going to enforce your rights is you're going to have to sue and say this is bad faith. Because companies can get away with a lot if your only recourse is a lawsuit. So what kind of limits can we put up front to say, okay, we only want you to use pooling in a responsible way? So we'll talk about anti-dilution provisions. I'll show you an example of one of those. We'll also talk about Pew clauses, which are very important, and then retained acreage or continuous development clauses. So here's an anti-dilution clause, and I want you to, as you read this, think about how would this help avoid a non-good faith use of pooling. All right. The lessee shall not be granted the right to pool any of the leased premises for the drilling of or production from any well located on the leased premises, which is anticipated to be classified or is ultimately classified as a gas well by the governmental entity having jurisdiction over the same, unless all of the leased premises is located either within the pooled unit for such well or within a unit for another gas well producing in commercially paying quantities from the same formation. Okay, so how does that help? Well, let's imagine 4 properties. And let's imagine that a company has a lease on all these properties. It has a lease on each property. And then it pools a unit that's like that. Now, what's the problem? Let's call that party C. What's the problem from C's perspective? Remember that in a pooled well, you share in the oil that's produced. So let's say there's oil right here, or the gas in this case. You share in that gas on the basis of your acreage included. So if you only have a tiny bit of acreage, you might have 40 acres, 100 acres, but only 1 or 2 acres are included. You're going to get just a tiny, tiny fraction of this well. Because imagine that well has pooled in 120 acres, and you have just 1 acre included. Well, then you're going to get 1 out of 120th of your regular royalty. So if all the land was produced on your property, you would get 1/8, but you're only going to get 1/120th because you're contributing 1 of the 120 acres to this well, and so you're going to get 1/8 of 1/120th. It's about 1,000th. 1/960th is all you're going to get. So that is bad news when you have just a tiny part of your property included. So how does this help? Okay. So what this says is if there's a well located on the leased premises, so imagine a well actually that's put in that corner there, the oil and gas company cannot pool a unit that includes other properties in that you're going to have to share that oil and gas with, unless the rest of your property is pooled in with other landowners producing in commercially paying quantities from the same formation. So basically, you share in every well based on how many of your acres are attributed to that pooling unit. And so what this anti-dilution clause says if you want to pool a well on my property with other people so they share in my oil, then you have to pool all of my property with other paying wells. So in other words, if I've got 40 acres, I want all 40 acres that are attributed to paying wells somewhere. Okay. So that seems nice. What are some problems with this anti-dilution clause? Well, one is, imagine that this well right here, just in the corner of your property, is actually the best well. So all of the wells have to be pooled with other ones that are producing in commercially paying quantities. So they're going to be giving you something, but maybe the well on your property is giving you the most. So that can be kind of a problem. There could also be problems. What if just in good faith there aren't wells on these other sides that can be shared in? And what if you can't actually drill a well on your property without pooling in other people because you don't have the acreage allowed? So it's got some benefits, but it's not super elegant. Let's look at some of the other solutions that people have used. So Pew Clause. What a Pew Clause does is it severs the portion of the lease from the unpooled portion. So if you have just a corner of your property that's pooled in to a well on other people's property, that part of the lease starts operating separately. And if the company wants to continue producing on the rest, continue keeping the rest of your lease, it's got to treat it like a separate lease. It's going to have to drill or pool it into some production, or attribute production to it. So, drilling operations on or production from a pooled unit or units established under the pooling clause shall maintain this lease in force only as to the land included in such units. The lease may be maintained in force as to the remainder of the land in any manner herein provided, so you can pay delay rentals, shut-in royalty, etc., provided that if it be by rental payments, rentals shall be payable only on the number of acres not included in such unit. So it just separates the lease. So if you just have a corner of your property that's pooled into some unit, that's not going to keep the whole lease forever. You're going to still have the primary term and the secondary term running with respect to the remainder, and that oil and gas company better find a way to get some production from that land or attributed to that land in other pooled units to keep it. So the Pew Clause is a little bit more elegant in that way. All right. So the Pew Clause, here's an example case. This isn't, you don't have the full case here in your book, but so here's an example of Pew Clause. In the event that only a part of the lands embraced by this lease are included in a unit created hereunder, then the remaining portion of the lands embraced by this lease shall be subject to delay rental payments as provided in paragraph 4. Okay, pretty basic, reasonable Pew Clause. The problem is this language italicized, and we'll talk about why. The lease was compulsorily pooled. So the state came in and said, you got to pool this. So the Pew Clause, remember, here says it had to be a unit created hereunder. What does that mean? Well, that means that the pooled unit was created under the pooling power of the lease by the oil and gas company deciding to pool the land. But if it's not the oil and gas company decided, but the state decided, then the question is, well, should the Pew Clause really be triggered because it wasn't created under the lease, it was created by the state, and so therefore, if the Pew Clause isn't triggered, you get to keep the whole lease even if you're only producing a portion of it under this compulsorily pooled unit. All right. Court says, nope, yeah, following the language of the lease, the Pew Clause not triggered because it was created by the state. All right. So to think about how some sort of more sophisticated ways that Pew Clauses work, it's helpful to think about a 3D version of the lease property. So here we got the surface, you could just have a little house on top, and you can see there's all these layers below, and there's different oil and gas formations at different levels. These appear to be conventional formations. You can see they're trapped up against caprock. In reality, nowadays, you might have a bunch of little, sort of pancakes. Each of these layers might have some oil and gas that you could fracture to release it. So imagine that each of these layers potentially has some oil and gas. All right. So the typical Pew Clause says if you pool acreage, that's separated from the rest of the lease. So if you've pooled this acreage, okay, from a bird's eye view, it looked like half. It would look, it would basically look like you pooled in this portion. Well, the rest of the lease has to be maintained separately. You're going to have to drill on it, pool it, somehow maintain that. Okay, so that's the normal, and we call it a vertical Pew Clause because it cuts the earth vertically. So if that's a stack of pancakes that are all filled with oil, you've cut them in half vertically. All right, now that's the norm, but a more sophisticated thing that often happens now, because there's often different layers of oil and gas, particularly with fracking, is that you want a horizontal Pew Clause as well. The horizontal Pew Clause can be structured in different ways. It could say you just keep the reservoir that you produce and not the other depths. Very commonly, it says you don't keep anything deeper than what you pooled. So if the pooled unit produced from this area, the horizontal Pew Clause would say, well, everything deeper than that has to be maintained separately. You don't get to keep that. So that's what we call a horizontal Pew Clause because it cuts that stack of pancakes horizontally and says everything lower than that you get to keep. Okay. Now, of course, a horizontal is definitely more sophisticated. So usually if you use a horizontal, people are using a vertical and horizontal Pew clause. And so they say, when you got this well here, you get to keep this half of the property only, and you only get to keep it to the depth that you drill. So everything down here you lose, and everything over here you lose unless you find a way to produce it. So more common, it's more common nowadays to have these vertical and horizontal Pew clauses. Okay. Now remember that a Pew clause, as we saw in that Bibler case, only applies when land has been pooled. But what if you have a really big ranch and the oil and gas company just produces one part of it? It doesn't need to pool to only to drill on your well, to drill on your land. So it just drills one well. Should that oil and gas company be allowed to keep your entire ranch that could support dozens of wells or hundreds of wells with that single well? Well, a Pew clause doesn't help you in that case, because the oil and gas company can just go ahead and drill without pooling, and it'll be able to keep your whole land. So if you have a bigger property, and I would just say in general, probably the ideal and more elegant way to approach it is to have a retained acreage clause, which just says, whether you're pooling or not, if you are only producing from a certain corner of my property, the rest of it goes back to me unless you find a way to keep it going. So the lease will be severed and you have to maintain the rest. So on page 326, you have this example. Upon pooling of part of the lease premises or completion of a producing well, this lease shall be severed and shall be considered as separate and distinct leases on A, the pooled acreage, or on the tract comprising the drilling unit for such well. So even if you didn't pool, you only get to keep that drilling unit. And B, the rest of the lease premises, and the term of each resulting lease caused by any such severance, and all the rights and obligation of lessee under each such lease shall apply separately to the acreage attributable to the particular lease under the foregoing severance. Okay, look at this lease. So this is a retained acreage clause. It's basically, retained acreage clause is just better than a Pew clause because it includes the pooling, but it says even if you didn't pool, if you only produce a portion, you just get to keep that portion. Now look at this retained acreage clause and tell me, is this a vertical or a horizontal retained acreage clause or both? This is just a vertical retained acreage clause because it just says you just get to keep the acreage for that drilling unit. So you would want to, probably a sophisticated landowner would want to have a horizontal provision as well that says, I get to keep all the depths that you don't produce, as well as the acreage that you don't produce. That goes back to me. So this kind of removes all those shenanigans about the oil and gas company finding ways to just keep your lease with a tiny portion of it. And it says, you go ahead and just put a corner of mine in, but then I get the whole lease back. So it protects you from those sort of bad faith or semi-bad faith pooling decisions by the oil and gas company.